please the court. Social media companies, while metaphysical, are still companies and reserve protection from the government to regulate as they wish, as per the First Amendment. My name is Lauren Holt, and along my co-counsel,
Han Lei, and we represent the respondent, NetChoice. The question before the court is whether a public official engages in state action is subject to the First Amendment by blocking an individual from the official's personal social media account. The answer is that they cannot, because private companies have a right to regulate their own business, and it fails a strict scrutiny analysis.
To start off with our first point, private companies have a right to regulate their own business. The companies adjoined as NetChoice in today's case have a right to regulate their own platform as expressive speech, as protected by the First Amendment, as the social media companies have a right to express their company as they wish to do so. Furthermore, companies taking down posts or accounts for any reason applies to that expression as an aspect of speech. Companies present themselves and what they stand for on the basis of what is upon their name, or in this instance, the post that they decide to not have on their app. The actions taken by social media companies, such as removing posts or suspending accounts, can be considered a form of expression. These actions reflect the platform's values and guidelines, essentially conveying what they deem acceptable or unacceptable within their community. While there's a complexity in defining where expression ends and regulation begins, while these actions can represent the platform's speech, they also serve to maintain community standards or comply with legal requirements, sometimes conflicting with the concept of free speech.
Social media is not a common carrier. Common carriers have a history of being regulated by the government due to monopolies, but social media companies are not common carriers as they are not able to form a monopoly. Monopolies are created due to scarcity of a product and the company's control of the majority of the same trade, and allowing for the company to create more appealing prices and run other companies in the same trade out of business. Although in the case of social media, there does not exist a platform which can become the biggest platform and run the others out of business. In cases of physical products buying, of course, there exists this buying that one business takes away from another, but not so in social media. Out of the over 4 billion users on social media, the average user accesses 8.4 social media accounts on different apps. Users are able to have more than one social media platform on their person, which does not allow for a certain group to monopolize the social media industry. Since they are unable to monopolize such industry, then the monopolizing of speech is also not something that can occur. Whereas monopolizing has occurred in common carriers such as oil companies, because this type of monopolizing cannot occur, it is not a common carrier. A law journal by Ashutosh Bhargwat titled Why Social Media Platforms Are Not Common Carriers claims that because social media platforms do not possess the same characteristics as typical common carriers, that these platforms simply shouldn't be held to the same standards as many common carriers would. A common carrier has been historically determined by Congress to be a necessity and place of utility. The Interstate Commerce Act of 1847 designated railroads a means of transportation as being a common carrier. Decades later, when the first telephone was invented, it was widely disputed whether this emerging industry should qualify as a common carrier. Congress resolved the issue by classifying telephone companies as common carriers, a designation which it confirms with the Federal Communications Act of 1934, a foundational statute for the future framework of telecommunications and broadcasting industries.
The internet itself can be considered a common carrier, but apps themselves cannot. For to do so would set up a system detailing internet businesses different from those that are physical. As things like trains, for example, are common carriers, but they have restaurants in them that are not common carriers. Apps are like these restaurants inside a common carrier, with people being on trains, but entering a different set of roles once entering the service of that restaurant, which then allows the apps in those restaurants to use their expression to show their business. Furthermore, common carriers are as they sound, carriers in which social media itself is not. Social media is a business that promotes the design of their app and its accessibility instead of just being a message system. Whereas some message apps are just that of message delivery, social media platforms are so much more, in which even products are being sold on social media platforms today, specifically set up by the social media app. Different from common carriers such as telephone companies who don't sell anything on their platform themselves. Where some telemarketers may call people to attempt business, this isn't specifically set up by the telephone company itself. At least to say that social media companies have a product that is the app themselves, not just moving around messages. Social media is not selling the app to carry messages, instead it is selling an app's design and features. Since the majority of persons have more than one social media app, then they do not choose their favorite based on simply wanting to carry a message they could do that on their phone or any app. Instead, a person chooses what social media app to use based on design, which is what social media is really selling. Common carriers move a product, but social media makes a product, their app, making it accessible, aesthetic, and functional software that they sell. If a person goes into an arcade, for example, with some friends and they speak in that setting, it is not that the business has become a common carrier of speech, but instead a place that attracts people based on design, opportunity to indulge in mental stimulus. Social media is a business relying heavily on design techniques, not on the words being traveled between users to run a business.
Social media also redefines editorial discretion. Editorial discretion as applied to social media companies, while similar to that of newspapers, is different in a few ways because of how posts are being distributed. Newspapers are allowed to determine what is and isn't on their articles and even edit them. And newspapers are allowed to determine what is and isn't on their articles, and also being able to determine whether they're going to be edited after they are posted. In such a way, social media can do that as well by being able to determine what they wish to portray on their app. The point in which they differ does lie upon liability, in which newspapers do have liability in what they write, which both can lie upon the company and the employee who writes the material that is being issued. But this is not the same for social media. Social media and its employees don't write their posts and therefore don't have the same liability. But they do have a right to editorial discretion in the same way that newspapers do. Section 230 embodies the principle that we should all be responsible for our own actions and statements online, which holds social media not liable to the actions of others. Social media does not edit their own platform to stop liability, but instead to further how they present themselves and their product, which is the app. Social media is a business which has to make a profit, and one of the ways that they're able to do so is by showing advertisements. Furthermore, these social media apps are trying to cater to specific audiences, which makes it necessary for them to maintain an image.
The second part of our argument is strict scrutiny, so the actions taken by the government fails the strict scrutiny analysis, and it is the adherent test. For Sorrell v. IMS Health Inc. specifically highlighted as a necessity of heightened scrutiny when dealing with the First Amendment, furthering the use of strict scrutiny for the case at bar. The difference between infringement and violation lies upon first glance. Often, laws may have to infringe on rights to serve an interest, but depending on the extent of the infringement, then that itself determines whether the law is in violation, in which using strict scrutiny in today's case, we can see that infringement has turned into violation. Because to start off, there is not a sufficient governmental interest on Moody's part. For the interest itself, it must be valid to even allow an infringement, and inspection onto its means of action. For the state to meet strict scrutiny, it must prove that there is a sufficient compelling governmental interest in allowing themselves to regulate privately owned businesses, and that is done by the least restrictive means. A compelling governmental interest that would justify limiting restrictions on social media companies would have to prevent a monopoly, as found in Turner Broadcasting System Inc. v. FCC, Interfering restrictions by the government are constitutional as long as it is to prevent a monopoly. The existence of monopolies can affect similar service providers. It is possible for a monopoly to take away consumers from another service provider. A prime example of this would be a cell phone service company. A person can only have a single cell phone service provider. However, for social media, people are able to have multiple accounts cross platforms. Someone owning an account on one platform is not going to affect another platform's performance. The introduction of antitrust laws has already shown the US government's interference regarding monopolies. The antitrust laws ensures that no company is immune to competition. Furthermore, the ruling in Standard Oil Co. of New Jersey v. United States demonstrates the initiative that the court has previously undertaken in order to diminish monopolies. In Standard Oil, John D. Rockefeller had an overwhelming control over the oil trade industry and had extended beyond a business, becoming that of an infrastructural corporation.
In the mentioned cases, the regulations were to prevent companies from becoming monopolies, and there had to be laws passed in order to limit that possibility. While Moody has a valid concern for leveling out the playing field, these social media apps have not been immune to competition. Therefore, the private social media companies have not had the possibility of potentially becoming a monopoly and an infrastructural corporation. So the state had been unable to identify a compelling interest that would call for a government restriction on private companies. Next, the laws that Florida is imposing are not in the least restrictive means. The proposed methods are not in the least restrictive means of achieving this interest, as there are alternative options of achieving the argued interest. The state's laws regarding content moderation on social media apps are limiting these private companies' rights as to how they portray their platform. In order for Florida to meet its interests, it is important to review other methods that also protects the speech of politicians without imposing restrictions on private businesses. There are still alternative options to look at when considering how this interest can be met, one of which includes developing an app specifically dedicated for a space for politicians to voicing and promoting their campaigns. This could actually end up being more beneficial because there would no longer be the routine of certain political ads reaching more viewers than others. Social media apps are paid to display these advertisements to its users, and it is possible for it to result in some campaigns being more recognizable than others. If there were to be an app regulated by the government and for the purpose of allowing political officials to freely speak out, then private companies won't have to meet limitations from the state, in which the government already regulates websites for themselves to ensure that they can present what they want. As such is the case with the whitehouse.gov, a website that contains President Joe Biden's political platform. Beyond a federal example, there also exists Florida.gov, which in itself is specific to Florida. As the respondent, we need only to show that there exists one alternative that is less restrictive than the current one, in which because there is one, then they have not met the least restrictive means.
Next, when dealing with strict scrutiny, it is important to notify or just bring up that strict scrutiny is an extremely high bar to pass. Most cases dealing with an infringement upon a constitutional right are required to look to a standard of strict scrutiny. This is the highest standard of review, above intermediate or rational basis. The government, or in this case today, the usage of the law, must pass both a governmental interest and the least restrictive means. Many cases do not pass strict scrutiny, such as Ashcroft v. American Civil Liberties Union. Congress passed the Child Online Protection Act, COPA, to meet a governmental interest of protecting minors from harm. However, the court could find that there were alternative ways which could have met the same interest, intended from the passing of the COPA Act. Therefore, this law was not enacted in the least restrictive means of meeting their goal by placing restrictions on free speech. Even in cases like Students for Fair Admissions v. University of North Carolina, it dealt with affirmative action within the university admission using the factors of an applicant's race. As the case involved racial classification, it was held to the highest standard of review, strict scrutiny. The compelling interest was to increase diversity on a campus to promote the cultural benefits in future employment after graduation. However, the methods employed by these higher education institutions were determined by the court to not be able to least restrictive means that they could have gone about increasing diversity on their campuses. Despite a prominently valued interest in promoting educational benefits, this court still retained that to meet the interest, there must be process which is the least restrictive means, and that least restrictive means in today's case has not been met, and therefore this high bar has not been passed.
It is for these reasons that we pray the court upholds the ruling of the lower court, ensuring that business upon the physical and cyber world maintain equal protection by ruling in favor of the respondent net choice.
Why is social media so important today?
Social media is so important today as it is a place which everyone has access to, and they can use these platforms to share their opinions. However, these are still private companies, which enables them to regulate the speech that goes on their site.
How does the Florida law restrict social media platforms' ability to engage in content moderation by removing, editing, or arranging user-generated content?
The content moderation provisions is limiting the social media platform's ability to deplatform political candidates for journalistic enterprises and requires that platforms only change their terms of service once every 30 days. This is limiting these privately owned companies their rights to apply their own standards of content moderation.
How does the Florida law require social media platforms to provide individualized explanations for certain forms of content moderation?
Social media platforms under the Florida law must provide a user with explanation of the removal or altering of a post. These companies also have to make general disclosures regarding their operations and policies, including publishing their standards for deplatforming, censoring, and shadow banning.
Why did Florida enact the social media law?
The purpose of enacting the social media law was to protect the speech of politicians, which Florida claims to be discriminated against by social media companies. Although this court has only found before a viable interest in impending upon the rights of private companies when they're preventing a monopoly.
What tier of scrutiny should the court review Florida's law with?
The court should review Florida's law under the standard of strict scrutiny. This law is not compatible with general applicability because it infringes upon a constitutional right and targets a specific group. Neither does it fall under intermediate scrutiny because the statute is not affecting a protected class of individuals. Therefore, this court should look towards strict scrutiny.
Do social media platforms resemble newspapers, which can control the editorial content?
To some extent, social media platforms do resemble newspapers. However, it is different here as newspapers are printed and the content is widely distributed with its content being tied back to the publication. While for social media, a post can be reposted, altered by different users that don't work for the company.
Does the compelled speech doctrine protect the rights of social media companies?
While the compelled speech doctrine generally applies to individuals, it can protect the rights of these social media companies as well. The doctrine protects the right to speech, and these companies are exercising this by content moderation on their platforms, as even not speaking expression is a form of speech.
Do social media platforms engage in commercial speech?
No, commercial speech would require for the social media platforms to profit off of their speech, or the speech that is going on there. However, if a company were to deplatform certain political advertisements on their sites, they're not getting profit by this and therefore don't engage in commercial speech.
Will the Florida law increase or decrease free speech on social media?
The Florida law would decrease free speech on social media, not to speak in the aspect of users, but in the aspect of companies, as the now social media companies will all be under the impression that they have to watch what accounts or posts they suspend, as they would possibly be condemned under legal action by the state, very much taking away from the freedom of speech as private companies do present their business as they please.
Does the Florida law create a slippery slope towards censorship?
Yes, the Florida law creates a slippery slope as it prevents social media platforms from having control as private companies of their very own presentation as a company.